Good afternoon. Thank you for the introduction, and also thank you to the organization for inviting me today. Intellectual property, not always perceived as the most lucrative or interesting subject, sometimes as boring, but it can create quite some value for your business, both for small businesses as for large businesses. I will talk today, I will start about IP strategy. I will give some examples of what the different types of IP are, the value creation, the most important part, the strategic importance of IP, and then an example of trade secrets and graphical user interfaces, which is quite relevant for behaving on the internet, of course. Now, why IP? Well, reason to have IP is to protect yourself, but not if it has no value, and to create additional value or revenue. And why an IP strategy? Well, to have a plan to be able to know what you're going to do with that IP. Now, IP strategy has different aspects that can influence, or there are different aspects that can influence the IP strategy. The first aspect is global trends. Digitization can influence technology and developments, but also, for example, geopolitical aspects. If with the current conflict between Ukraine and Russia, if Russia decides to protect less IP from certain regions of the world, that can influence your IP strategy to file less there, to do less there, and to take some conclusions. Then the industry trends, depending in which industry you are. For example, some years ago, consumer electronics companies, both in Europe but also in Japan, they walked away a bit from the consumer electronics because that was a business that created less value, but they entered into the healthcare sector. That, of course, means that also your IP portfolio has to change. You cannot keep with an existing IP portfolio and stick with what you always had. IP trends, what is happening in the IP world. For example, also a number of years ago, there was a discussion, a software debate. Can software protect it with intellectual property? That depended on how you looked at it. A pure algorithm could not, but applications of software could. And that was a severe discussion for a lot of industrial companies, because if applications of software could not be protected anymore by IP, it would have a huge effect on portfolios of companies using software for technical applications. Then, for example, the company strategy. Where is the company going? Divestitures, acquisitions, going into new areas, stepping out of existing areas. That can also influence what you're going to do with your IP. And then, last but not least, of course, the IP ambition of the company. What would the company like to do with their IP? Would they like to use it defensively, or would they also like to create value? How do they think the company can grow by using the IP? We will come back to those value creation opportunities. The IP strategy, often it is thought it's of the IP organization, or it's the person of IP, a person who is responsible for IP in the company. But that's not the case. It is a cooperation between different parts of the company, also with marketing, with research and development, because when defining an IP strategy, you will need other people to be able to execute it. You cannot define it in a silo, because you also cannot execute it in that silo. Now, what are the different types of IP? I think if I ask people what are the types of IP, Often the most prominent one that comes up is patents. That, of course, is an important one. It protects technical aspects, and it is, but it is quite an expensive type of IP. Another one which is related to that is utility models, but that is not everywhere available. It has lesser requirements than, for example, getting a patent, but the utility model is very popular in China, and it also exists, for example, in Germany. And because there are so many in China, it is often harmful for your novelty if you want to file something elsewhere. Then it comes up during the granting of your patent, but you cannot do a lot about it. It's a fact that, that exists. Which is very related to patents and can be a complement to patents is trade secrets. I come back to that example of trade secrets, but trade secrets are used also for technical features that, for example, you don't want to patent, you don't want to get them in the open because you want to keep them secret, but you want to have a certain protection, or for things that cannot be patented and you want to keep them secret anyway. Then designs for the outer appearance of products. Aesthetic features is not about technical features, but how does your product look like. And then trademarks and domain names. It's not because I missed a box that I put them together. I put them together because they are very much related to it. When you look at the strategy for trademarks and domain names, you often align them with each other, because if you have a trademark and you also want to be present online, then it's good that those two are connected and that you regularly see whether you keep track of both and whether you have everything aligned. And then the last one is copyright. That is something you don't have to do anything for. It just exists when you create something. It doesn't protect the content. It exactly protects what you created. Now, how can those different types of IP create value? Also, those different types of IP, they can be combined. Sometimes a combination of these types can create the optimal protection for a product. You can have only a patent, but you also can have a patent in combination with a design or with a trademark. Now, how can these types of IP create value? For example, the first one is monetization. That is when you have IP and you get royalties in return for the IP that is used by third parties. That can be, for example, for patents, but that also can be for brands. And in that way, for example, if you license your brand to another company, that company has to fulfill, for example, the quality requirements, sustainability requirements of your brand, and then they can use the brand for products that they produce. And in the end, you are in the market with more products than you are producing yourself. Another type is, of course, IP sales, but yet that you can do only once. If you sell your IP portfolio, then, or part of the IP portfolio, that's a one-off sales. But that is often done when a portfolio is not interesting anymore for your company or for your products, and when it is relevant, for example, for another company that wants to pay for it. Another possibility is exclusivity. In that possibility, you keep your patents and your products exclusive. You don't want to license your patents to your IP to any other company. You keep it for yourself, and you have the exclusivity in the market. The condition, of course, is that you have reliable, high-quality products and also innovative products that others stay away. Then there is the defensive model. That means that you have an IP portfolio that can keep others away because they don't attack, because you can attack back if you want with your portfolio. And you can also make sure that you have a broader protection than what is really needed. To give an example of a design, for example, if you have a product with a certain design, you make these designs, but you make also other designs which come very close to your design. You will never use that design, but it's good to have designs around, and that makes it possible that other companies stay further away from your product because they also have that other fence around, not your product only, but also things that look very similar. Because my industrial background is from Philips, it was the Senseo, which is now already quite some time in the market, but that was an example. There was the design of the Senseo, and there was a broader design around that would never be used for the Senseo, but that could keep other products away. And then finally, the exchange model. That exchange model is, for example, cross-licensing, where you exchange, that's the terminology we use for exchanging IP in the same area between companies. That could be for free if the exchange is in balance, if the piles and the quality is in balance. That could be with a payment from one to the other if there is no balance. And then mutual agreements is exchange of portfolios in different areas. So cross-license in the same area, mutual agreement in another area, but the result is in fact similar. Now, in what way do these business models create value? The monetization is, of course, direct revenue. It's royalty income. The exclusivity, because you're exclusive in the market and others are not allowed to get a license, you can create extra margin. You can make your products more expensive, which is, of course, also direct income, but for the business that produces the products. Then defense, that is to create freedom. I said with the fence, you create freedom by fencing off others. And with the exchange, there you can create savings. And why savings? Because you get access to patents and IP from other companies, that you don't have to start your research from scratch, that you don't have to file these patents, so you exchange your IP against other IP with no extra costs if needed. Now, the strategic importance of IP. COVID vaccines are very fresh in our minds, I think. And they are subject to several litigations. In 2020, Moderna launched a patent pledge. And a patent pledge means that we will not enforce our patents against anybody who is using that technology. But a license or saying that we will not follow anybody, that does not necessarily mean that the ones who would like to produce a similar product, that they exactly know what to do. Because those vaccines are very complex, data are involved, know-how is involved, trade secrets can be involved, and if they don't have access to that, then you can ask whether a patent pledge is useful. That patent pledge is only useful if there is also additional knowledge transfer, at least if you want to have the same safety, and especially in this kind of area. Then later on, Moderna said we will stop with the patent pledge, but we will not follow any company in 92 middle and low-income countries, but so they shifted the patent pledge, but that will not hold for Germany and the US, for example. So that's still, if there is infringement in Germany or in the US by companies, then that may lead to litigations. Then there are some other examples of litigations. For example, CureVac against BioNTech, and also Moderna sued Pfizer and BioNTech. And there are many others. There are no outcomes yet, and usually that takes quite some time because results of this kind of activities are clear. This is something you all is very close to all of your heart, I think. Everybody has a smartphone. But what is behind is not only the revenue of selling these items on the market, but in 2018, Apple and Samsung were in litigation. And that was not only about patents, so the vaccine example was about patents. This is about designs. And it was about the design of the face, the bezel, and the graphical user interface, where there seemed to be infringement by Samsung. So that led to a huge amount of payment by Samsung to Apple. And there were many other lawsuits going on at that time. So graphical user interfaces in this type of devices and interacting with other electronic devices can be very important to protect. Now also in these devices there are patents as well. And patents, as when a device has a lot of patents, usually they are spread over a lot of owners. So if somebody wants to produce such a thing, they will have to go via several patent owners to be able to get a license and to be able to produce such a tool. Now, examples of patents that are present in an iPhone or in a smartphone in general is the cellular network. You have to use the cellular network to be able to communicate with each other. And that's a standard. So that's the patents that relate to that network, they are called standard essential patents. So you cannot make a smartphone without using those patents. Then you have the operating system and the camera that are commercially available, commercially necessary patents. It's not commercially interesting if you cannot have a camera, for example. So also there are patents, so you need to see which companies do have patents on this camera. Then there are the interface patents. There is a universe to choose from. And then, of course, there are the designs. So it's the more complex a product is, the more people will have patents. And what is often done, and certainly for the standard essential patents, that there is formed a patent pool. And then they bring all the relevant patents, all the standard essential patents, they bring that into a patent pool. And when people outside, usually there is an arrangement that they can then use these patents within the participants of the pool, paying or not. And then outside the patent pool, it's a one-stop shop. So if you need the patents, the standard essential patents that are gathered in that patent pool, and you're outside that patent pool, you have a one-stop shop and you get a combined license for what you need under these standard essential patents. Now, I explain it as if it is quite simple, but standard essential patents are also subject to a lot of discussions, because you can imagine that if there are a lot of standard essential patents in a pool, every participant would like to have their share, and they will get their share, but usually they want to have a higher share than the share that comes to them. So there's a lot of discussion, and that's called FRAND, fair and reasonable conditions, and non-discriminatory conditions, so that the stack of the royalties still seems reasonable for somebody who wants to take a license, which is not always felt reasonable by people that are in the patent pool and contributing with their patents. Then, so we had patents, we had design, and now we have also trademarks and designs together. Here are some examples. The first example, the Louis Vuitton bag. In general, fashion industry suffers a lot from counterfeit. So it's important that they protect their design and that they also have the necessary resources or external parties that can help them to find where the fake is coming in. They work a lot with investigators. They also train customs at important borders. Training customs on patents is quite difficult because then they have to read the patent and the claims. Training customs on designs and trademarks is much easier because they have the pictures and certain characteristics they have to take care of. And if they see such loads coming in, they can warn the company. Then the company has to come where the load has come in, and then they have to check and confirm, and then actions can be taken. The Starbucks trademark is also very popular for counterfeit, especially in China. In China, you see a lot of publicity of Starbucks alikes. They indeed sell coffee, but it looks as if it is Starbucks, and when you come closer, you see that it is not Starbucks at all. Then an example of Philips. It's a combination of trademarks and design infringement. It's the three-head shaver. They look very similar, and on top of that, there is another brand on the box. Now, the reason why that sells good in China is because China sees the name of a company as a logo and not as separate characters. So for them, Philips and Philibus looks quite similar. And then you have the three-head shaver. Of course, usually the fake one is much cheaper. Can also be more painful, but that is not that dangerous. You just feel it. It's not threatening. But if that happens in medicine, there is also counterfeit in medicine. They look very similar, but the content can sometimes be very poisonous. And that is very dangerous in countries like China, Russia, where a lot of fake medicines are produced. And that's dangerous for health, of course. Then the example below was an example of IKEA. Had nothing to do with IKEA, but a completely look-alike store in China was made according to the IKEA brand. And then, in general, sports clothes is also very popular for counterfeit. They do not always keep the color they originally had, but that's quality, of course. And that's why I put on top, it's your brand reputation with designs and trademarks and domain names. It's your brand reputation, and it's also a quality label that guarantees that, when it is that company, when it is that brand, we know that it is good quality. It can also be that you say, that company, never good quality, but at least then the brand did that kind of work as well. And then I come to the two examples. Trade secrets. So I said before, trade secrets you usually use when you don't want to have a patent or when you cannot have a patent. And that is then for protecting the technical part. For example, inventions, designs, drawings, algorithms, processes, know-how in general, also formulas. But there are also other things of trade secrets, and that holds for any company, even a company that does not technology development or research. But for every company, there are examples what are trade secrets, like customer lists, supplier lists, strategic documents, consumer profiles, marketing plans. And if you want to you can keep it confidential, but then you do not really have a proof. You can label it confidential. But on the top you see that there are different types of information classification. And public means, it's open to everybody. Confidential means that you can use it for a restricted number of people, and usually they also have to know that it is confidential. For that, often a non-disclosure agreement is used. And then the people, I cannot tell you, I'm now going to tell you something confidential. That will not work. That's only to a limited number of people. Then the internal use only. Often in companies they have the label internal use only, which means that it may not go out of the company. And then we have secret and trade secret, but just keeping something secret does not mean that it is a trade secret. A trade secret has strict requirements. One of the requirements is, of course, that it has to be secret, but it needs to have commercial value. And you need to be able to prove that only a limited number of people were aware of that secret. I'll first go to the examples. KFC, the combination of the herbs that they are using seems to be a trade secret. It is widely known that the recipe of Coca-Cola is also a trade secret. They say that only 3 people know parts of the recipe, but none of the 3 people know the whole recipe, just to avoid that the recipe would leak. And a trade secret holds forever, so they can keep that secret for many, many years more than so far. But these 2 examples are always mentioned, and they are always far away in the US. But even closer, we can find a trade secret, a known trade secret, and that is with Lotus Bakeries for the cookies, the Biscoff. Also, the combination of the herbs that they use for their cookies seems to be a trade secret. Now, on the right-hand side, in the figure, you can see there is technical information and there is business information. In the middle, there is, of course, the secret information, and only part of that secret information qualifies as trade secret. And why? Because if you want to enforce your trade secret, if you want to prove that somebody else is using that trade secret, you can only do that if there is misuse. You cannot do that for parallel development somewhere. You also have to prove that it has been misused, it has been stolen. And where most of that's an attention point for all companies, big and small, where trade secrets have been stolen. Biggest part, I think it's 80% of the trade secrets that are considered to be stolen are taken away by internal employees and by business partners that you're working with. It's not the malicious people that are all around you that try to steal something. It's a lot internal. People that are going to leave the company, or are planning to leave the company, business partners, also sometimes by accident. So that is something that it's in every company, in fact. It's important that people are aware what is the information classification, properly classify the information, and also tell what the consequences could be if that goes wrong somewhere. And a trade secret, of course, can go on forever until you disclose it, of course. But as I said, with Coca-Cola, as long as those 3 people and they hand over each time to a successor and it remains 3 people and they don't tell anybody else, it can go on forever. You also don't have to pay anything for it. You only have to take some measures that you can fulfill the conditions. And then the last example, it's a lot of text, but it's again about the graphical user interfaces. And when working online, it's an important part to protect. Now, what the difficulty is with graphical user interfaces, it is a kind of design protection. It belongs under design protection. In the US, they talk about design patents. In Europe, we talk about industrial designs. But this is a type of design. But it is not, the law is not harmonized. So it depends on where you would like to protect your graphical user interface, that you have to take into account different considerations. For example, the connection between a physical product and the graphical user interface, sometimes that needs to be present, sometimes not in some jurisdictions. Then when you have a moving picture, you can protect that sometimes by animation, or by different pictures, but in some jurisdictions that is not possible. Then sometimes a description is required, in other cases it is not. So it is very much dependent on where you want to protect your graphical user interface. And when you would like to do that, it's also, again here, it's for all types of IP to define upfront where you would like to protect your IP strategy, regional, national, international, on a global level. So define upfront what you want to do. But that in fact holds for all types of IP. Think upfront what you would like to do, and an IP strategy is not carved in stone. It is normally it is reviewed every few years, and if needed, if things change, you can go back earlier, because you have to follow up on how your company develops, on how the developments in the world are going, and what brings out the most value in your portfolio. Thank you.